State's attorneys present, defendant and defense counsel are present. Is there anything we need to take up before we bring the jury in, Mr. Coleman?
Not from the state judge, just a procedural matter. When we get to closing, we'll be splitting, Ms. Gasper and I will be splitting up our closing.
Okay, we'll take a break and talk about that. Thanks. Mr. Reynolds, anything?
Nothing from us at this time.
Okay, you can bring the jury in. Good afternoon, everyone. Let the record reflect the jury seated, state's attorneys present, defendant and defense counsel are present. Mr. Coleman, you may call your next witness.
Your Honor, the state calls Dr. William McLean.
Good afternoon, sir.
Hello.
Do you swear to affirm the whole truth and nothing but the truth?
I do.
Thank you, sir. You can have a seat. You may proceed.
Thank you, Your Honor. Good afternoon, Dr. McLean.
Good afternoon.
Would you please state your full name for the court reporter?
I'm William McLean.
And you are a medical doctor, correct?
I am.
And you've had a couple, you've had a busy couple of days, is that fair to say?
Yes, sir.
How many subpoenas have you had for the last couple of days?
Well, this is the fourth case I've testified in, and a handful of the subpoenas that let out or fell through or what have you.
Well, thanks for making the time to be here. Excuse me. Please tell the ladies and gentlemen of the jury how you are employed, sir.
I'm a forensic pathologist and a medical examiner for Forensic Medical Management Services.
And what's your training and background that has led you to hold that position?
I obtained a Bachelor of Science in Biology from the University of Texas in Arlington, and then I attended medical school at the University of Texas Health Science Center in Houston. I completed an anatomic and clinical pathology residency at the University of Texas Health Science Center in San Antonio. And then I did a one-year fellowship at the Bexar County Medical Examiner's Office in Forensic Pathology, which is also in San Antonio. I'm board certified in anatomic pathology, clinical pathology, and forensic pathology.
And your duties, do they include performing autopsies?
They do.
And forensic medical management, what is forensic medical management?
It's a company that provides autopsy services here in the southeast part of Texas. We serve 23, 24 counties in southeast Texas and 5 or 6 parishes in southwest Louisiana. When the justices of the peace, or in Louisiana's case, the foreigners, are tasked with determining the cause and the manner of death of an individual who dies in his or her precinct in one of the counties we contract with, then that justice of the peace will send the body to my office here in Beaumont, and we do the autopsy, and then we tell the justice of the peace what we think the cause and the manner of death.
And you've mentioned forensic pathology a couple of times. What exactly is forensic pathology?
We start with explaining what pathology is, and that literally means the study of death and diseases. And if you've ever had a biopsy taken of your skin or your colon, if you've had a blood sample taken and they measured your glucose or your cholesterol, if you've had a pap smear or a bone marrow testing, anything like that, in the clinic or in the hospital, that's sent to the pathology department. And those are clinical pathologists and anatomic pathologists looking at those things under the microscope, plugging them into machines and interpreting the results that and then they give to your physician who knows what to do with those results. And that also includes patients who die in the hospital on occasion will get an autopsy performed by a pathologist at the hospital. And so then if we take that study of pathology and apply it to the legal world, where there are crimes or potential crimes committed, or we just don't know what caused the person to die. It's not a patient in a hospital, but rather someone found at home, for example. Then we are determining the cause of death in that situation. And the primary tool that I use, the primary procedure that I use, is an autopsy, along with blood testing and that sort of stuff for toxicological reasons.
Okay. And so that is essentially an autopsy. Is that fair to say?
Correct.
What we as lay people will refer to as an autopsy.
Yeah, and an autopsy is the procedure I use the most to examine externally and internally and determine what caused the person to die.
And that examination externally and internally, is there a process associated with that?
Yes, sir.
Kind of a generally accepted method throughout the profession?
That's right. We have standards that are set by our national accrediting agency.
And briefly, what do they include?
Sure. So for each individual getting an autopsy, it starts with the external examination. I guess I should say it really starts with getting a snapshot of the background information, the scenario that led to this person being discovered dead or having died. And that's very similar to when you go to your physician and you say, hey, doc, here's what's been going on. I've got a headache behind my left eye, right? So you give that information to your doctor, and I get information provided to me. So then I do an external examination, collecting whatever kind of evidence I might need to collect, trace evidence, documenting injuries, documenting medical interactions and paraphernalia stuff to the body, clothing, eye color, hair color, that sort of stuff to identify the person. And then once that external is complete, then I'll do the internal examination with the Y-shaped incision that you're probably familiar with, and removing the chest plate to observe all the organs in situ. Then we remove them one at a time, we weigh them, process them, see the external and the internal structures, documenting the pathological conditions along the way. And then we do the same with the head by reflecting the scalp and opening the top of the skull and removing the brain. All along the way, making observations as to what I find. And if there's any special dissection techniques I need to do, any samples I need to collect, if I need to look at tissue under the microscope, just about anything like that I can do.
And throughout the course of your career, have you performed few or many autopsies?
I think many.
And if you had to put a number to it, if you had to guess, how many, approximately how many?
Approaching 4,000.
Have you testified in court on few or on many occasions?
Many.
And have you testified as an expert witness?
I have.
Have you or did you have the opportunity to review, or have you had the opportunity to review the autopsies of other pathologists?
I have.
And when you were reviewing those autopsies, are you looking for those processes or that process that you just described to make sure that that was followed?
Absolutely.
And have you had the opportunity to testify as to the results of your review of other pathologists?
Yes, sir.
And did you have the opportunity to review the autopsy performed on a you've got it listed as John M. Janice on April the 18th of 2023?
Yes, sir.
Who performed the initial autopsy in that case?
Dr. Danielle Armstrong.
And Dr. Armstrong is no longer with Forensic Medical Management, correct?
That's correct.
And because of that, as a result of that, did you review her autopsy for the purposes of testifying here in court today?
I did.
And any reason to believe that the process that you just described for the jury was not followed by Dr. Danielle Armstrong?
No.
When a person or a body is received by Forensic Medical Management, is it assigned a unique case number?
It is.
And that unique case number, does it follow that individual throughout the entire autopsy and the case?
Everything that individual has to do with our office, that number is associated with.
And that number is placed on a, is it fair to say on a band or on like a wristband?
Yes, sir.
Also an ankle? Is it also on the ankle?
Ankle, wrist, both, one or the other.
What was the unique case number that was assigned in this case?
23-0382 BMP.
Now, your review of the autopsy, does it also include a review of the report?
Yes, sir.
Does it include a review of the photographs that were taken during the autopsy?
Yes, sir.
And what about a review of the lab reports, if any?
Yes, sir.
And you, as an employee of Forensic Medical Management, are you considered to be a custodian of record for Forensic Medical Management?
Yes, sir.
And the reports, more specifically, the report that Danielle Armstrong generated from her autopsy of Mr. Janice, was that report created at or near the time that Dr. Armstrong performed her autopsy?
Yes, sir.
And she certainly would have been a person with firsthand knowledge of that autopsy, correct?
Yes, sir.
And that autopsy would have been maintained as part of the ordinary course of Forensic Medical Management, correct?
Yes, sir.
And that, in your review of that, those documents, do you have any reason to believe that the documents were altered in any way?
No, sir.
Your Honor, at this time, the state would offer what has been marked as State's Exhibit number 16, and I'm intentionally skipping over 17, and I'll offer that later. And then 16 and 18 through 24 as business records authenticated by this witness, and for the purpose of the record, tendered to defense counsel for your inspection.
No objection from the defense.
States 16 and then 18 through 24 are all admitted.
Thank you. Now, was there also a lab report that was generated or created? Well, was there a lab report? Let me just ask you that.
Yes, sir.
How did that lab report come about?
During the course of the autopsy, blood samples were obtained, and then the autopsy technicians from our office packaged that up and sent it off to a laboratory we got an agreement with, as a contract with, to test those samples. And then they generate the report and send it to us.
And that lab, would it be NMS Labs?
Yes, sir.
Your Honor, at this time, I'd offer State's Exhibit number 17 through a certificate of analysis that has been on file with the court for the requisite period of time, and I don't believe it's been objected to.
Judge, there's no certificate of analysis attached to this report.
It's the report, Judge. I filed it with the certificate of analysis.
You should have it in your, it's been filed in the case. If you, I can pull that up if y'all need a copy of it.
like to see a copy.
I have a hard copy.
No objection to 17, Judge.
17's admitted.
Dr. McLean, let's talk about the contents of the autopsy report first before we get to the lab report. You mentioned the external examination. Was there anything remarkable about the external examination in this case?
No, sir, nothing too remarkable.
What about the internal examination? Was there anything that was remarkable in that regard?
I guess going back to your previous question about the external examination, part of that includes addressing the clothing and property that accompanied the decedent. So there were several apparent prescription medication containers that came with him, with the decedent, and in one of those was a small plastic baggie containing a white powdery substance. So that is remarkable about the external exam, I suppose, though it had nothing to do with his actual physical body. Related to the internal examination, Mr. Janice did have an enlarged heart. He had obvious evidence of long-standing hypertension, stiffening of the heart muscles. He also had atherosclerosis of the coronary arteries. It was rated as severe, so he had pretty significant occlusion and narrowing of those coronary arteries and his aorta. And then some changes to the kidney called nephrosclerosis that is characteristic of people with long-standing high blood pressure.
After all, he was a 68-year-old individual, correct?
That's correct.
I mean, are any of those conditions atypical of a 68-year-old individual?
Not nowadays, no.
Okay. Anything else with regard to the internal examination?
No.
Walk through some of these photographs, if we could. For the record, I'm publishing State's Exhibit number 18. Is that the unique identifying number that's associated that you testified to earlier?
Yes, sir.
State's number 19. What are we looking at there?
This is what we call our as-is photograph, and it's documenting the body as is when we unzip the body transport bag. It's been unzipped and the top has been unfurled, and then a rolling stair step device is put up next to it. Climb up top and take a picture overall, just to show the clothing, the bag of apparent medications, that sort of thing.
And State's Exhibit number 20, is it fair to say that's just a close-up of that as-is photo?
Correct, obviously the upper part of the body.
And State's Exhibit number 21, is that the unique identifying number there as attached to the deceased ankle?
Yes, sir.
Along with other identifying information, is that fair to say?
That's right. It's got county that sent that body to us, obviously his name and the date of his death.
State's Exhibit number 22, just another shot of close-up of that individual?
Yes, sir. Showing no trauma, anything unusual about the face, about the chest.
State's Exhibit number 23, I believe you mentioned some prescription pill bottles. Is that what we're looking at there?
It is, yes. This is the collection of prescription medication containers that accompanied the decedent.
And lastly, State's Exhibit number 24, is that the pill bottle that you testified to that had some, what's fair to say, I guess, an unknown substance in it?
Correct. You'll see it's labeled amlodipine, which is a prescription medication. This is clearly not amlodipine in the small plastic baggie, and that small baggie contains that gray white powdery substance, and that baggie was discovered inside that container.
Now let's talk about the lab report. Do you have a copy of it there in front of you?
I do.
Let's talk about the page 1, the results of that lab report. Let's start with the level. Well, what does it indicate as with regard to fentanyl? Let's start with the fentanyl first.
Sure. The fentanyl was quantified as 13 nanograms of fentanyl per milliliter of blood.
And in that same lab report, I'm referring to page 4 or 7, they've got a reference, some reference comments there. Please help the jury understand those reference comments as it relates to the level of fentanyl, and then maybe your own interpretation or your own professional experience of as it relates to the level of fentanyl.
Sure. Pardon me 1 second. I didn't quite fish out page 4 of that. With each of these reports, the laboratory has comments for each substance, but specifically for fentanyl.
I'm referring to the second paragraph on that, at the top of that page.
So it's reported that patients lost consciousness at mean plasma levels, average blood levels, fentanyl of 34 nanograms per milliliter when infused with 75 micrograms per kilogram of body weight over a 15-minute period. Peak plasma levels average 50 nanograms per milliliter. In fatalities from fentanyl, blood concentrations range from 0.30 all the way up to 110 nanograms per milliliter. The median concentration was 11 nanograms per milliliter. And that was in 301 femoral blood specimens obtained from accidental drug overdose death investigations. So these concentrations range from 9.7 to 41.3 nanograms per milliliter, with a median of 17.2 nanograms per milliliter. In 7 fentanyl-only cases in another published case series.
2 things I want to focus on in that paragraph, Doctor, and I think you may have inadvertently not read this sentence where it says, in fatalities from fentanyl, blood concentrations are variable and have been reported as low as 3 nanograms per milliliters. So is it fair to say that it's been reported that people die or have died with as little as 3 nanograms per milliliter, according to these comments?
Yes, and if I must have just accidentally skipped over that sentence. I see. The word concentrations twice there, stacked on each other. Yes, a lower level of 3 nanograms per milliliter is sort of the cutoff that I use most of the time to decide if it's above 3 nanograms per milliliter, then it's probably going to be fatal, probably going to be what I certify as the cause of death.
And again, in this case, what was the nanogram per milliliter amount?
His blood concentration of fentanyl was 13 nanograms per milliliter.
Almost, what, 3 times, more than 3 times the?
Yeah, more than 4 times.
More than 4 times the low level as reported by NMS labs that could result in a death. Another number or data point I'd like to focus on is the range. That last sentence in that paragraph where it talks about these concentrations ranged from 9.7 to 41.3 nanograms per milliliter. Is it fair to say that this 13 that was in the blood of that John Janice is within that range?
It is.
Now, this is their comments, the NMS Labs comments on fentanyl. Please share with the jury your take on the data, your experience as it relates to fentanyl, and whether or not you have a different spin on it than what EMS has.
Generally speaking, I use the cutoff of 3 nanograms per milliliter. If you're above that, it's probably going to be fatal. All of these concentrations have to be interpreted in the proper context of that specific individual, and nothing can be applied in a blanket generic way. So an otherwise healthy marathon runner with a level of 3.1 nanograms per milliliter, presumably not chronically using fentanyl to treat a medical condition, then that's probably going to be fatal, especially if he has no other obvious cause of death. Then the one deranged finding must be, is most likely the cause of death. If you were a 65-year-old person who had had 3 back surgeries and been on chronic pain meds for the last 28 years and have been on fentanyl patches for the last 5 years, then a level of 3.5 is probably no big deal, and you could probably even tolerate up to 10 or 12 or 15, maybe even 20 depending. So it all has to be taken in context. If you have a lower level of fentanyl, but you have 4 other different opioid medications, like hydrocodone and those kinds of medications, hydromorphone, in your blood along with this fentanyl, well then they probably all work together to perform the same function, which is to stop your breathing and kill you. So in that case, you would combine them together.
It sounds like you mentioned a legitimate medical use for fentanyl. Is there what is called a therapeutic use for fentanyl?
Yes, sir.
Okay. What is it used for? Pain management?
Chronic pain management for individuals who have incurable pain. You can think of someone with metastatic bone cancer, for example. It also has use in acute pain. Someone in a car crash being rushed to the hospital and they've got to take them straight away to emergency repair surgery. They'll load those people up with a bolus of fentanyl kind of on the way to the hospital to ease their pain.
And on the other end of the spectrum, from a therapeutic use or medical use, there's also the toxic use or lethal amount. You want to expound on that? Or?
Yes, sir, and we refer to that as illicit use or illegal use, not prescribed by a healthcare professional. And this is becoming a pandemic. It is an epidemic for our country. It kills hundreds of thousands of people. And it is available to purchase on the street, like we know heroin and cocaine and marijuana and other illicit drugs are available for purchase. This medication, people are able to manufacture it at home, or in the case of China, in large factories in China. Then it's sent over in powder form or pressed into pills, or if it's in powder form and comes here, then cartels all over the North American continent will press them into tabs, and then they're made available for purchase either in tablet form or powder form on the street, like many other illicit drugs. And then they're obviously being used without the supervision of a healthcare professional, and they're being abused and overused, and we're having people die from fentanyl use in epidemic proportions.
Dr. McLean, let's talk about the other substances that were found in the blood of the deceased. What else was in the blood?
A relatively low concentration of ethanol was detected in his blood, along with...
Let me stop you there on the ethanol. That's alcohol, right?
That's drinking alcohol, sir.
Go right ahead.
Amlodipine was detected but not quantified because it's just a prescription heart medication. Cotinine and nicotine. Cotinine is a derivative of nicotine that just tells us that you smoke a cigarette. And then 7-aminoclonazepam is a metabolite of clonazepam, which is a benzodiazepine medication used to treat anxiety disorder. Also can be used for seizures too.
And when you say metabolite, that means that, what does it mean? I don't want to put words in your mouth.
Yeah, metabolite is a breakdown product, so when you eat a cheeseburger, your body immediately breaks it down into proteins and fats and that sort of thing. And when you take a medication, your body immediately starts to break it down. So in this case, when clonazepam was ingested, if the body immediately started to process it, to use what it needs to use, to eliminate what it doesn't need, and one of those things that is detected that we can measure is 7-aminoclonazepam. and that was detected in this case.
So in other words, it's the and please correct me if I'm using the lay person's terms too loosely, but it's the after effects of taking or consuming that drug?
No, you can imagine any chemical is kind of constructed out of building blocks, Lego pieces, you might say, a couple red ones and a yellow one and a blue one, and then you ingest it and your body will break it down into a yellow one, a blue one, a red one, and a red one. And then your body processes it from there. So 7-aminoclonazepam is one of the building blocks of clonazepam.
I guess what I'm getting at is if it's already being broken down or having been broke down, is it fair to say that it was not recently consumed?
No, it's not necessarily fair to say that. Some substances like heroin, we could watch a person inject heroin into his vein, fall over dead, and I could take his blood sample and not detect heroin because it gets metabolized that quickly. And we can only tell someone in that instance ever used heroin because we find a metabolite that is very unique to heroin and heroin only. So we never detect heroin, we detect its metabolite, and it tells me he had heroin. Could have been just mere seconds before he died, and the body will process it that quickly. Other substances stick around for hours or even a day before we can detect it for 20 hours after use and still get the parent compound and maybe get a few metabolites also.
Very good. Please continue with the other substances.
The next substance on the list is doxylamine. There's a chemical called MCPP, and that's a breakdown product of the next item on the list, which is trazodone. So again, that's a parent compound trazodone, and MCPP is the metabolite.
Trazodone, is that, or could it be a prescription medication?
It is generally a prescription medication. There's a little bit of talk about it occasionally being found as a contaminant in some other illicit drugs, but generally that's only detected as a prescription medication. Next is diphenhydramine, which is better known as Benadryl, available over the counter. Hydroxyzine is a prescription medication. Again, that's another one that, although it is a valid prescription medication, it has also been detected recently as a contaminant in some illicit drugs found on the street. And then here is fentanyl. Its primary metabolite, norfentanyl. And then a chemical called 4-ANPP, which is a metabolite of fentanyl, but it is also a precursor of fentanyl. And so when individuals, the presence of 4-NPP in the 4-ANPP in the blood tells me that this fentanyl is not derived from pharmaceutical grade, laboratory manufactured prescription fentanyl, but rather illicitly made fentanyl. And you imagine when you're trying to chemically construct a chemical like fentanyl, you can take some of the ingredients and mix them together, and then you get fentanyl. Well, one of those ingredients is 4-ANPP. And so that is used in the manufacture of fentanyl. Its presence in the blood tells me, not all of it is used up when you're making fentanyl. Some of the residual sticks around. And so its presence tells me that this is almost assuredly illicitly manufactured fentanyl. This is not pharmaceutical grade fentanyl in Mr. Janice's blood.
Please, next.
Next, the next items are a group of markers that we test in the vitreous fluid, which is the clear liquid in the back portion of the eye.
And we don't need to, I'm sorry to interrupt, we don't need to go through that if none of those are controlled substances or illicit substances.
They're not. They're just markers of kidney function and electrolyte balance and whether somebody has diabetes or not. And none of these results were unremarkable and contributed.
Okay, very good. Well, so other than the substances, the fentanyl and these other substances in the body of Mr. Janice, was there any evidence of disease or a physical defect that was the cause of death for Mr. Janice?
No, sir.
Any evidence of an injury that was the cause of death for Mr. Janice?
No, sir.
Based on your review of the report, photos, the lab, did you form an opinion as to what the cause of death was for Mr. Janice?
Yes, sir.
In your opinion, did it coincide with the opinion of Dr. Armstrong?
It did.
And what is that opinion, sir?
The acute combined intoxication of fentanyl, trazodone, doxylamine, clonazepam, hydroxyzine, and ethanol.
So essentially the combination of all of those drugs, including fentanyl.
Yes, sir.
Given the level of fentanyl, what, if any, opinion can you derive or did you derive as to the role that the fentanyl played or the lethality of the fentanyl, if my question is clear?
I think I understand your question, and my opinion is that the fentanyl is by far of the listed substances detected in his blood. The fentanyl is by far the most lethal of them, but not for the fentanyl in his blood. The other substances would not have combined to such a degree as to cause his death.
Now, this autopsy also, excuse me, mentions the manner of death. It clarifies, it characterizes that manner of death as a quote-unquote accident. Please explain to the jurors the different types of classifications for the manner of death and why it would be characterized, at least here, for the purposes of an autopsy, as a quote-unquote accident.
Sure. So we classify deaths into one of generally 5 categories are accepted. One is a natural, and that's more or less self-explanatory. An old fellow who dies of a heart attack from eating too many cheeseburgers. The second would be a suicide, and that's when one person ends his own life with his own intentional action, which was meant to take his life. Then a third would be homicide, and that's when one person takes the life of another with an intentional act that he knew or should have known would probably result in death. If we can't decide, we can call it undetermined if we just have no idea what happened, or if it's a tie between 2 different manners of death and we can't tell which one is which, then we could call it undetermined. But the last is accident, like we see here, and that's, and from my perspective, in my world, that is an action that a person takes on his own, or it's an occurrence at the hands of another person that results in death, but there wasn't an intention to cause that person to die. There was no, in this case, when we're talking about the toxic effects of a substance, the decedent didn't ingest this medication or this substance and this fentanyl with the intention and the hope that he would die. No one else secretly injected it into him without him knowing, as a homicidal act with the intention to kill him. So that's where we use the term accident, kind of to distinguish from things like suicide, certainly not natural and not homicide.
And just to be clear, when that term is used in the context of a autopsy, you're in no way speaking to the legal culpability or responsibility under the laws or the penal code of the state of Texas.
No, thankfully I don't have to worry about that.
Good. Now, just really quickly, really briefly, explain to the jury how one dies from a fentanyl overdose.
Sure, fentanyl is an opioid substance, and so almost all the cells in your body have on their surface what are called receptors, opioid receptors, and they're just proteins that are attached on the surface. You can imagine like fingers on your hand or hairs on your head. But specifically, you have a dense concentration of them in your central nervous system and in the areas that control your breathing, your heart rate, and these sort of bodily functions. You think of your fight or flight type of reactions, right? The instinctual impulse you have to run when you hear a loud kaboom, or at least turn to get away from it, that fight or flight. So you have dense opioid receptors there on those cells. When you ingest an opioid, that chemical will move and connect onto those receptors, and a whole cascade of events happens downstream from that. In this case with opioids, it acts to shut down the activation of those cells. So this is why you don't feel pain when you take an opioid medication, because that chemical is telling your brain, what you feel, when your finger is cut, that's not really pain. You're not feeling that. It's still, the nerves are getting damaged in your finger, but your brain just doesn't know that it's happening because all of those pain receptors are plugged up by fentanyl, by an opioid medication or substance. So when you take too much of it, you overwhelm that system. You turn all of it down. You desensitize it. It no longer functions. So not only are you not feeling pain, but then your brain is being told, slow down the heart rate, slow down the breathing, slow everything down. We're in rest mode. We're not in fight or flight mode. It turns off your fight or flight. It turns all of that off and puts you gradually drift into a deeper level of unconsciousness. So at first you're just a little drowsy. You struggle to keep your eyes open and your head bobbing. Then you progress to full-blown sleep. You can't wake up. Then you continue down that slope. Then you start to snore as your breathing is slowing down. You have a rattle in your lungs as the fluid in your blood leaks out into the air spaces as your heart rate slows and the river quits flowing so much, the bloodstream quits flowing. Then that fluid will leak into your lung spaces. You develop that rattle, that gurgle, and then you eventually continue down that slope into a coma and then death.
And just a couple more questions, Dr. McLean. Fentanyl, it's considered a controlled substance under penalty group 1B of the of section 481.1022 of the Health and Safety Code, correct?
As far as I know, yes.
And is it a violation of the Health and Safety Code section 481.1123 to either manufacture and or deliver or possess with the intent to manufacture or deliver fentanyl?
Not sure about the numbers, but I know that it is illegal to possess and manufacture.
Very good. That's all I have. I'll pass the witness, Your Honor. Thank you, Doctor.
Thank you, sir. Mr. Reynolds?
Fentanyl has a therapeutic use, is that correct?
Yes, sir.
And it is a prescription drug when properly prescribed and used.
That's right.
And how is that drug normally dispensed?
Usually, for chronic pain patients, there's a patch that has the medication sort of into this gel layer that is applied to the skin, and the skin absorbs it. It can also just be given in the hospital through IV to treat people who are in acute pain going to surgery.
I was looking at the lab report, and it talks about a transdermal preparation of fentanyl would have been a 25 to 100 microgram per hour patch. Was that be a normal way that fentanyl would be prescribed and delivered from a doctor?
It is, again, in chronic pain patients, yes, sir.
And it says with use of that patch, serum fentanyl concentrations were up to 3.8 nanograms per milliliter have been reported within 24 hours. Is that a reasonable amount of fentanyl after clinical use of that type of patch?
Yes, sir.
And you also said that when the prosecutor asked you about elevated uses amongst chronic pain patients or long-term drug users, the lethality of fentanyl could be higher than 3.
Oh, yes.
And I'll go over this again, that it says, I don't know how they did this test, but they said that reported that patients lost consciousness at mean plasma levels of fentanyl at 34 when infused with 75 micrograms per kilogram over a 15-minute period. Is that a study they did?
It looks like it, yes, sir.
Were those people killed? Do you know anything about that?
I don't know specifically about that study, no, sir.
Okay. But they got those people up to 34.
It looks like it.
And it also says that let's see, the median in accidental drug overdoses was 11. Is that correct, according to what?
That is what it says, yes.
And they range from 9.7 to 41.3. Median was 17 in fentanyl only cases. And this gentleman had 13 kids. When you list his, in your report, back where his medication log, I think it's the last page, was this made out by your office, to your knowledge?
Do you have that?
It would be on exhibit.
Okay, I have the exhibits, in fact, I need to put them back up there.
Okay, I'm gonna show you State's Exhibit 16, which has been admitted into evidence in the approach judge.
Yes, sir.
On the last page. Now, how was that log created?
Yes, this is created by, in our office, based on that stacky of prescription medications that came with him.
Okay. And I want to direct your attention in particular to the sleep medication that was prescribed, or was listed there. Do you know what kind of sleep aid that was?
Looks like, I'm not exactly sure, maybe if it was captured in a photograph. I wonder what the name like that, if it's not some over the counter,
Unisom?
maybe it's something like that, maybe, I'm not sure. I did not look in great detail at the photo of whatever that might have been, but the fact that it's just listed as sleep aid and not a prescription name makes me think maybe some sort of over-the-counter something or another like Unisom.
Is Unisom an over-the-counter medication?
It is.
And it normally come in a 25 milligram capsule?
I'm not 100% sure, but
if you'll look also under, so that's doxylamine, Unisom, back to the lab report, exhibit 17. We have that.
I have my own copy of the
Okay.
lab report though.
Okay. On the lab report on exhibit 17, I guess where it talks about doxylamine, that would be the Unisom, correct?
Yes, that sounds right.
And the result there is 810.
Mm-hmm.
How do you get to 810 taking a 25 milligram capsule?
Oh goodness, yeah, I'm not sure the amount you'd have to ingest to get there, but you know, it all depends on how he processes it. It looks like it takes quite a bit to become lethal as far as Unisom goes.
Let's see, in the lab report it says peak plasma concentration average 99. In overdosage, doxylamine can produce sedation, respiratory depression, and coma. Are you reading that on number 6, third page of the lab report?
Yes, sir.
And correct me if I misquote it, but in overdosage, doxylamine can produce sedation, respiratory depression, and coma. Fatal blood doxylamine concentration between 700 and 12,000, mean of 6,500 have been reported. So the 810 would be within that range, is that correct?
Well, it's within the range of concentrations that have been reported in people who were dead. So it is within that range. It's well below the median. So what to make of that number 800 when the range is from 700 to whatever is a little tough. And then what this doesn't tell us, was there anything in those cases where the concentration ranged from 700 to 12,000, this statement doesn't tell us that there were any other substances associated with it that makes 700 doxylamine lethal, or are we talking about 700 of doxylamine completely alone? That, in my opinion, would be very difficult to hang the death on doxylamine alone at 700. If it's combined with something else.
I'm not trying to do that, but I'm just saying he had a bunch of Unisom in him when he died.
But he did have a hefty amount of Unisom. Yes, sir.
And the mysterious green white powder that was found in one of the pill bottles, Was any analysis ever done of that to your knowledge?
Yeah, I don't know if it was not.
But your office certainly did not do that.
No, sir.
Were all those materials returned back to the Jefferson County Crime Lab?
I'm not sure about all of them, but I am confident that bagging with that substance was retained as evidence and given to whatever law enforcement agency was handling the case.
Okay. Pass the witness, Judge.
Thank you. Mr. Coleman?
I have nothing further for Dr. McLean, may he be excused, Your Honor.
Any objection, Mr.
No
Reynolds?
objection, Judge.
Thank you, Dr. McLean. You're excused, and you're placed under the rule, and you know what that means. Mr. Coleman?
Your Honor, this time the state of Texas rests.
Thank you, Mr. Coleman. Mr. Reynolds, are you ready to proceed, or do you need a short break?
If we could have a short break, Judge.
Let's, ladies and gentlemen, we'll take about a 15-minute break. It is 2 o'clock. We'll try to get started at 2:15. Keep in mind all those instructions that you were previously given. If everyone else would please remain seated, you are excused for about 15 minutes. All right, let the record reflect the jury is outside the presence of the courtroom. Do you need a break, or is there anything you need to discuss at this point?
I can have maybe 5 minutes. Judge.
Sure. So we'll just come back a little bit before. I am printing out also new copies of the court's proposed charge. I took out the 2 sentences in the bad act paragraph or evidence of wrongful acts. And that was just standard to put in there. Do you both agree that it should be in there? I mean, were there
Yeah. I think it should be in there.
enough other allegations, I guess, of,
I mean, I think the paragraph should be there.
okay, just
Yeah, I
making,
mean,
just
there
making
was-
sure.
There was other wrong acts.
Okay, just
Evidence of, yeah.
making sure of that. And then I added the definition after recklessly of deliver and adulterant or dilutant as they are in the code, so the health and safety code. And that's printing out now, so I'll take a short break, get those to y'all, make sure you go over them. If you don't anticipate having a witness, we'll go straight into that when we get started again. So we'll be in a short break. Attorneys present, defendant, and defense counsel are present. Anything we need to take up before we bring the jury back in?
Not from the state, Judge.
Judge, I have reviewed with Mr. Lowenthal his right to testify and his also his right not to testify. And after review and consultation with me, he's made the decision that he will not testify in this case.
And Mr. Lowenthal, that is in fact your decision?
Yes, ma'am.
Okay. Anything else on the record then?
No, ma'am.
Let me, what about the new court's charge that I gave you both? Anything else come up with that?
No, Judge.
We have no objections, Judge.
No objections from the state.
Thank you. I will, give me another copy. How long would either of you ask for closing?
10 minutes, 15 on the high end, but
Okay.
around 10 minutes, Judge.
Okay, you good with that? Okay. All right, you can bring the jury in. All right, let the record reflect the jury is seated, state's attorney's present, defendant and defense counsel are present. Mr. Reynolds, you may call your first witness.
Judge, the defense rests.
All right, thank you, sir. All right, ladies and gentlemen, what that means is that you have heard all of the evidence that will be presented in the trial. And so the next thing to do is for me to read the court's charge to you. I'm required to read it in full, and then you will have the copy with you to take to the jury deliberation room. Cause number 24, DCCR 1911, the State of Texas versus Harry Francis Lowenthal. Jury instructions. Members of the jury, the defendant, Harry Francis Lowenthal, stands charged by indictment with the offense of manslaughter. The defendant has pleaded not guilty, and you have heard all of the evidence. The parties will soon present final arguments. Before they do so, I must now give you the instructions you must follow in deciding whether or not the state has proved the defendant guilty. You will have a written copy of these instructions to take with you and to use during your deliberations. I will first tell you about some general principles that apply in all criminal cases. Then I will instruct you on the rules that must control your deliberations. Finally, I will tell you about the specific law applicable to this case. General principles. The indictment is not evidence of guilt. The indictment is a document required to bring the case before you. Do not consider the fact that the defendant has been arrested, confined, or indicted, or otherwise charged. Do not draw any inference of guilt from any of these circumstances. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless the state proves each element of the offense beyond a reasonable doubt. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient for you to return a verdict of not guilty. You may find the defendant guilty only after a careful and impartial consideration of all the evidence, and only if the state has proved the defendant's guilt beyond a reasonable doubt. The state has the burden to prove every element of the offense beyond a reasonable doubt. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. If, after you have considered all the evidence and these instructions, you have a reasonable doubt about whether the defendant is guilty, you must find the defendant not guilty. As the jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention any other thing that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the lawyers are not evidence. Nothing I have said or done in this case should be considered by you as my opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in the instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits if those inferences are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. You may, if you wish, examine the exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for your examination. Certain testimony will be read back to you by the court reporter if you request. To request that testimony be read back to you, you must follow these rules. The foreperson must make the request in writing and sign it. That request must, 1, state that it is requesting that testimony be read back. 2, state that you have a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identify the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that is in dispute. The law requires that you render a verdict of either guilty or not guilty. The verdict of not guilty simply means that the state has not proved the defendant guilty beyond a reasonable doubt. You may return a verdict only if all 12 of you agree on this verdict. When you reach a verdict, the foreperson should notify the court. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf. The defendant may also choose not to testify. The defendant's decision not to testify cannot be held against him, and it is not evidence of guilt. You must not speculate, guess, or even talk about what the defendant might have said if he had taken the witness stand, or why he did not. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. Evidence of wrongful acts possibly committed by defendant. During the trial, you heard evidence that the defendant may have committed wrongful acts not charged in the indictment. You are not to consider that evidence at all unless you find, beyond a reasonable doubt, that the defendant did in fact commit the wrongful act. Those of you who believe the defendant did the wrongful act may consider it. Even if you do find that the defendant committed a wrongful act, you may consider this evidence only for the limited purpose I have described. You may not consider this evidence to prove that the defendant is a bad person and for this reason was likely to commit the charged offense. In other words, you should consider this evidence only for the specific limited purpose I've described. To consider this evidence for any other purpose would be improper. Rules that control deliberations. You must follow these rules while you are deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go into the jury room. Your first task will be to select your foreperson. The foreperson should conduct the deliberations in an orderly way. Each juror has one vote, including the foreperson. The foreperson must supervise the voting, vote with other jurors on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. 1. You must not discuss this case with any court officer or the attorneys or anyone not on the jury. 2. You must not discuss this case unless all of you are present in the jury room. If anyone leaves the room, then you must stop your discussions about the case until all of you are present again. 3. You must communicate with the judge only in writing, signed by the foreperson, and given to the judge through the officer assigned to you. 4. You must not conduct any independent investigations, research, or experiments. And 5. You must tell the judge if anyone attempts to contact you about the case before you reach your verdict. Your sole duty at this point is to determine whether the state has proved the defendant guilty. You must restrict your deliberations to this matter. After you have arrived at your verdict, you are to use the form attached to these instructions. The foreperson should sign the line that corresponds to your verdict. After the closing arguments by the attorneys, you will begin your deliberations to decide your verdict. Law specific to this case. The defendant, Harry Francis Lowenthal, stands charged by indictment with the offense of manslaughter, specifically that the defendant did recklessly manufacture or deliver a controlled substance, namely fentanyl, and an individual, namely John Marion Janice, died as a result of injecting, ingesting, inhaling, or introducing into the individual's body any amount of the controlled substance manufactured or delivered by the defendant, regardless of whether the controlled substance was used by itself or with another substance, including a drug, adulterant, or diluent. Relevant statutes. A person commits the offense of manslaughter if the person recklessly causes the death of an individual. A person causes the death of another if but for the person's conduct, the death of the other would not have occurred. Definitions. A person recklessly causes the death of an individual if 1. There is a substantial and unjustifiable risk that his conduct will cause that death. 2. This risk is of such nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all these circumstances as viewed from the person's standpoint. And 3, the person is aware of but consciously disregards that risk. Deliver means to transfer, actually or constructively, to another a controlled substance, counterfeit substance, or drug paraphernalia, regardless of whether there is an agency relationship. The term includes offering to sell a controlled substance, counterfeit substance, or drug paraphernalia. Adulterant or diluent means any material that increases the bulk or quantity of a controlled substance, regardless of its effect on the chemical activity of the controlled substance. Application of law to facts. You must determine whether the state has proved beyond a reasonable doubt 2 elements. The elements are that, number 1, the defendant in Jefferson County, Texas, on or about April 15, 2023, manufactured or delivered a controlled substance, namely fentanyl, and an individual, John, Mary, and Janice, died as a result of injecting, ingesting, inhaling, or introducing into the individual's body any amount of the controlled substance manufactured or delivered by Harry Francis Lowenthal, regardless of whether the controlled substance was used by itself or with another substance, including a drug, adulterant, or diluent. And 2, the defendant did this recklessly. You must all agree on elements 1 and 2 listed above. If you all agree the state has failed to prove beyond a reasonable doubt 1 or both of elements 1 and 2 listed above, you must find the defendant not guilty. If you all agree the state has proved beyond a reasonable doubt both of the 2 elements listed above, you must find the defendant guilty. And then that has my signature on it. And then the final page is the verdict form. And at the top, it's verdict, not guilty. We, the jury, find the defendant, Harry Francis Lowenthal, not guilty. And then there's a place for the signature and the printed name of the foreperson. And then below that is verdict, guilty. We, the jury, find the defendant, Harry Francis Lowenthal, guilty of manslaughter as charged in the indictment, again with the signature line and the printed line for the foreperson's signature. And Mr. Coleman, you have the right to open and close arguments. Ms. Gasper, are you going to open?
Yes, Your Honor.
Okay.
May it please the court?
Do you want me to let you know a certain time, or are you good?
I should be good.
Okay.
You'll let me know at 5 minutes.
Sure. Yes, ma'am.
May it please the court, counsel. Good afternoon, ladies and gentlemen. For the last few days, you've heard from several witnesses, you've seen exhibits on the board, you've seen and heard all the evidence in this case. And I want to briefly just get up here and discuss with you a few things before I hand it over to Mr. Reynolds, and then again you'll hear from Mr. Coleman before you get to go back and deliberate. And you just heard the judge read the charge to you, and I want to highlight a few points on this. You will get a copy of this charge to go back, and I encourage that you read through it, you ask questions, you discuss it. You will have this copy. And I want to turn your attention to the bottom of page 1. You just heard the judge read it, but I want to emphasize a few things. And that is that the state has the burden to prove every element of the offense beyond a reasonable doubt. Mr. Coleman talked about this in voir dire. The state has the burden of proof, and we have to prove all the elements. We've been discussing the elements since y'all were sitting out there on the voir dire panel. We've discussed them as we've moved throughout the trial. And now you've heard all of the evidence that proves the state has proved each of those elements. Under that first sentence, it states that if the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. If you remember back to yesterday when y'all were seated in this box for the first time, you took a second oath. And part of that oath is that you have a duty, and part of your duty is that if the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. You took an oath to do so. And in a few minutes, I do ask that you do so. Now, next I want to turn your attention to the final page of this charge. And that is that actual elements of this case. And there are a few that have gone undisputed throughout the presentation of the evidence. You've heard from several witnesses, and those elements that have gone undisputed are that in Jefferson County, Texas, you've heard from many people on the stands that this happened in China, which is in the limits of Jefferson County, Texas. On April 15th of 2023, John, Mary, and Janice died. And today you heard from Dr. McLean. And Dr. McLean told you that John, Mary, and Janice died as a result of fentanyl introduced into his system. Now, another one of the elements is, regardless of whether that controlled substance, fentanyl, was used by itself or with another substance. But you heard from Dr. McLean just recently that John, Mary, and Janice died as a result of fentanyl in his system. It was introduced into his system. And the final sentence of this charge, before you get to the verdict sheet that you will have at the end of this, again, it states that if you all agree, all 12 of you have to make this decision, and I encourage you to all participate and discuss and speak your opinions in your mind and work through this and use your own common sense. If you all agree that the state has proved beyond a reasonable doubt the elements above, you must find the defendant guilty. I've enjoyed getting to present this case to you over the last few days, and I look forward to your verdict. I'm going to turn it over to Mr. Reynolds, and then you'll hear from Mr. Coleman again before you get to deliberate. Thank you.
Thank you, Ms. Gasper. Mr. Reynolds?
May it please the court, counsel, ladies and gentlemen. It's a tragic situation that we've seen here, that fentanyl has taken another person. And you heard from the doctor that more than likely this fentanyl that contributed to the death of Mr. Janice was produced in an illicit lab. And you've also heard from him that it comes from China or wherever to come into the United States, probably through illegal channels, and has nothing to do with what happens in Jefferson County. I mean, I'm sure the law enforcement is doing all they can, but when you dump millions of pills into the country, they're going to find their way to people like Mr. Janice. So let's look at what the state put on as their evidence. And like Mr. Coleman said, at the start of this case, he thought it was fairly simple. Well, the case is fairly simple. He put on 2 admitted drug abusers, and they were probably not truthful to you, and they may have had a motive to tell you a lie. And I'll start with Christine. Well, let's go back. This person passed in April of 2023. The investigation didn't really start until December. And the officer explained to you that the reason for that is they had to wait on the toxicology reports. And when they started looking into it, they saw that fentanyl was a problem, and everybody knows that fentanyl is a problem, so they're going to go after, for whatever reason, they want to blame somebody. So they went and they talked to Christine and Claude, the drug users that were living in the house with John, who was also a drug user. According to the testimony, they would buy drugs and split them up. And we're not sure where John got the drugs from. You know, Claude testified that they would sometimes buy drugs, pool their money, and go buy it, bring them back to the house, and split them up. Now, who gave John the drugs on the day that it happened, we don't know. But when he died, did you hear any evidence from the EMT that came on the scene or the sheriff's office where they're saying, oh, Harry gave drugs to John, he died? No, nobody said anything about that. Wasn't until the law came back knocking on their door that all of a sudden their story comes out. Oh, well, yeah, it was Harry. We heard him on the phone with Harry. Well, Officer Powell saw some text messages from the decedent, from John, between he and Claude. And John was asking for some more stuff. And what did Claude say? Sure, I'll get you some. It's 5 days before he died. Now, normally you kind of look at, I mean, cases like this, there's no witnesses to the handoff, and they don't have any, they're not gonna have any. You don't know what happens, so you go back and you look at the phones and see what they say, and that's what the text messages say. Yeah, I'd like to get some more. Did Claude give it to him? Was Claude ever a suspect? No. Why not? I really didn't get an answer to that question. I think you can answer that. Was he? Do you have a doubt? Beyond a reasonable doubt? Is Claude off the hook? What about the decedent's cell phone? They looked at the last call made, and they traced it back, they say, to my client. What about all the other phone calls on there? Sure it wasn't. Did they look past that? No. Could have been buying product from anybody else? Well, I'm sure. You know, they testified fentanyl was everywhere. I'm sure he could buy it wherever he wanted to. They even found something in a pill bottle, as the doctor testified to, and they said it actually got from his house to the lab, backed up to the lab to the county morgue to the lab, and they discovered it there and pulled it out. And we still don't know what that is, where that came from. I mean, wouldn't that be something that, you know, I'd like to be able to bring to you and explain to you what that was and where it came from. Were there prints on it? Were there DNA? We don't know. You know, the pill bottles themselves, if my client had transferred a pill bottle, let me show you one of the exhibits here. I'm going to show you State's Exhibit 5. It's a picture. And it's the bedroom where they found John Janice before he passed away. And you'll notice on the counter and on the floor, there's empty pill bottles. We don't know what was in those pill bottles. We don't know whose fingerprints were on those pill bottles. We don't know if there's any DNA on them. If it came back to somebody that's not in this case, probably be Rowan. Since we don't know, that creates doubt. All right, now we'll get to Christine. Christine said that she's bought drugs before, but they changed, and she was taking fentanyl, and she had some kind of an episode and passed out in her car. She's taking fentanyl. Goes to the hospital. Talking to the hospital staff. Here's her hospital records. You can look at them. Baptist Hospital for Claude. Baptist Hospital for Christine. All right, she goes in the hospital. These are in her records. These are in evidence. You can look at them. Says she took an injection of Dilaudid. Lied to the hospital people. Then, when they go to test her, I asked her, you heard me, they take your blood? Oh yeah, they took my blood. Guess what? No blood. Lied again. What's she covering up? Probably the fact that maybe she has fentanyl. I don't know. That's a question that needs to be answered. That raises an issue as to whether maybe she's the one that furnished fentanyl to the decedent. This is a case where a man is facing time in prison. And you all have to decide if the state has resolved those doubts. Those are reasonable doubts. Have they resolved them? No, they have not. didn't look at John's cell phone records, or at least they did. They only pulled one phone record off of it. Now, they claim that there was a delivery, a drug transaction, that John left the house with his debit card. But what do people do with debit cards? They go and they get cash off of them. Where's that? Maybe it's not there. You don't buy drugs for free. If John would have bought drugs, he'd have got some money. If he'd have got some money, I would think they'd have brought it up to y'all. They didn't. Debit card records are fairly easy to find. They found cell phone records where they located my client's cell phone from a witness at AT&T going down Highway 90 to a restaurant, possible. So the and I did ask the technician when they put the display on the board about the cell phone, that he doesn't know if he went to the location or not. What about the decedent's cell phone location? Does it match up? Oh, we don't have that. No, no. We put those phones in the same place. That kind of creates that gets rid of some of the doubt that you all have. We've shown, or they've shown, where my client's phone went, assuming he had it with him, and it was consistent to go into a popular diner there right on Highway 90 in China, Texas, and driving back to Beaumont on Saturday afternoon. No crime there. Now, if they'd matched that up with the decedent's phone, it's a different story, but they didn't do that. That's, that evidence is not in front of you. Now, this is not my case. It's not my client's case. It's the state's case. And the judge has told you that the state has the burden to prove that. They have the burden to prove, you know, where John Janice was, and where my client was. They were together. If he gave the drugs to him, I'll concede that he had fentanyl in the system. It's probably an overdose. I don't know if it was intentional or not, but he got fentanyl from somewhere. I'll also tell you that when I asked Claude, I said, well, are you an addict? No. Anybody that's been around, had experience with drugs, knows that if you're a recovering addict, you're always an addict. He should have admitted to being an addict. He did not. He continued to lie about his condition, as he probably did during the whole testimony. I think they haven't proven, I know they haven't proven that Harry gave anything to the decedent at all. The only evidence they have is from two people that have a reason to lie to cover up their own bad acts, possibly. 8 months they've had to cover up their story, sweep that house, clean it out. You think they were scared when the police first came over? Think they were worried that the police may have been looking at them? They didn't say anything. It wasn't until 8 months later, all of a sudden, this man's name comes up. And the police officer gets on the stand, and they didn't look anywhere else. It was Harry, do or die. That gives me doubt. It gives me doubt in the law enforcement. It gives me doubt in the evidence, the testimony from the two star witnesses of the defense. The police officers weren't there. They don't know anything. They know that a man died, and they know those two people lived with him. And they know that he had a cell phone, and they know that Harry's phone number was on it, and they know that Harry traveled to somewhere near China on the day that John Janice died. They do not show that he delivered any drugs to him. And the only people that have been shown to have been involved in drugs around John Janice were the two star witnesses that got up here and testified to y'all, probably untruthfully. I'm asking you not to convict a man on a testimony.
Thank you, Mr. Reynolds. Mr. Coleman?
Thank you, Your Honor. May it please the court, Mr. Reynolds, ladies and gentlemen of the jury, on behalf of the District Attorney's Office, on behalf of the victim and the victim's family, John, Mary, and Janice, and on behalf of your community here in Jefferson County, I want to thank you for your time. Thank you for your attention in this case. I want to piggyback on a theme that I started during jury selection, that theme being the symbolism, the representation that Lady Justice has for our justice system. The blindfold representing being unbiased, the scales representing weighing the evidence and equities in the case, and that sword representing the power, the authority, the ability to hand out justice, the appropriate amount of justice. I have no doubt that with regard to that first symbol, the blindfold being unbiased, that you have kept to your oaths during the presentation of the testimony and the evidence in this case, and you have listened and received that evidence in an unbiased fashion. Next, I ask that you now, as you transition to the deliberation phase, that you weigh the evidence, not unlike those scales of Lady Justice. You weigh that evidence using your common sense and your life experience. Not my words, those are the words that are in the jury charge. The jury charge tells you to view the testimony and the evidence in this case through the prism of your common sense. As Ms. Gasper told you, the focus of my remarks to you will be on the two remaining elements in this case. Those elements are delivery and recklessness. Did this defendant, Harry Francis Lowenthal, deliver the fentanyl that killed John, Mary, and Janice? And was that delivery of the fentanyl reckless? Okay, let's talk about what the evidence in this case has shown. The evidence in this case, through the testimony of Claude Gaspard and through Christina Flores, has shown that the defendant drove to China, Texas on the day in question around the time that the victim died from a fentanyl overdose. The testimony in this case, which is evidence, testimony is evidence, and we talked about that during jury selection, that if you believe that testimony beyond a reasonable doubt, then that's all you need. The testimony in this case, through Claude Gaspard, showed that he overheard a conversation about money being on a card that was owned by John, and that John told him that he was going to go meet Harry. The testimony from Christina Flores was that she saw a truck that was associated, that she knew to be the truck of Harry Lowenthal there in the area. That day, she told you, both of them testified, they purchased and consumed fentanyl from this defendant, Harry Francis Lowenthal, as recently as a month prior to the death of John Janice. If you believe that, then that's enough for you to find this defendant guilty. If you believe that testimony as being truthful, and think about this, what does Claude and Christina, what do they gain from coming in here and being put on the stand in front of strangers and having to testify about their drug use and abuse and criminal history records, the embarrassing nature of overdosing and having to be taken to a hospital as a result? Why and who would put themselves through that? I submit to you, someone who's telling the truth. One thing I also neglected to mention was that Christina said that this defendant, while I don't have to prove that he had knowledge, specific knowledge that that controlled substance contained fentanyl, she testified that he told her, the defendant told her, be careful, this stuff has fentanyl in it. So again, if you believe that testimony, that's all you need in this case. But I'll submit to you, you've got more than that testimony. Fortunately, you've got those cell phone records. Those cell phone records don't lie. You saw and you've heard the testimony of Detective Flores. You saw how that cell phone moved out to China and moved back to Beaumont during the time in question. And it would be mighty coincidental, pretty coincidental, that this defendant just decided to go grab a bite to eat out in China around the time that the defendant, the victim, had consumed a lethal amount of fentanyl. Again, use your common sense. Does that make sense? We talked about the fact that I don't have to bring you all or every piece of information that you'd like. I mean, would we like to see surveillance video? Would we like to have DNA? Would we like to have 3 nuns who saw this drug transaction go down? That would be nice. But remember that puzzle of the puppy that we talked about, that I used as an example during jury selection? If you got enough of the pieces of the puzzle here that satisfies you in your head, your heart, and your gut, that this case, that the way that we presented to you happened beyond a reasonable doubt, then that's all you need. And I submit to you that's what you have here. So that's essentially what I want to say on the matter of the delivery aspect. Now let's talk about recklessness. It is undoubtedly reckless to deliver fentanyl. Who wouldn't know? Remember the definition of recklessness: disregarding a substantial risk of death. Who wouldn't know that fentanyl presents a substantial risk of death? You either have to be living under a rock or marooned, shipwrecked on an island, to not know nowadays with the billboards out there, the one pill can kill billboards, the television ads, and the news reports. Who wouldn't know that there's a substantial risk that someone that you give fentanyl to could die? And under the evidence that we have here, it is clear that when this defendant delivered the fentanyl to the victim in this case, John Janice, that he disregarded that risk. So I don't know that you need to spend a lot of time on that, but that's my take on the evidence. Make no mistake that it was fentanyl that killed the victim in this case. I just want to reiterate what Ms. Gasper said, and it's in the jury charge again. It is the fentanyl in combination with anything else in the system of the deceased. I mean, that's really all you need, but I submit to you that there's more based on the testimony of Dr. McLean, in that he said it was a lethal amount of the fentanyl that was the driving force behind the death of John Janice. So I just want to reiterate that part. And one thing, based on some of the responses that I got during jury selection, I want to make sure I address with each of you is that, again, following that theme of being blindfolded, representing being unbiased, I submit to you that please be unbiased as to the fact that John Janice was a drug user and possibly a drug abuser. That is not, I submit to you, something that needs to be considered with regard to the guilt or innocence of this defendant. He may have been a drug user, he may have been a drug abuser. I will borrow a term that Ms. Gasper used when we were prepping this case, and I thought it's most appropriate, that John Janice, he may have wanted to get high, but John Janice did not want to die, okay? And I thought when she said that, that's exactly what we got here. So don't hold it against John Janice for wanting to get high, because he certainly didn't want to die. There's no evidence here about suicide or anything like that, no suicide note or anything like that. Now, it may be a factor for you to consider in punishment, the fact that John Janice was a willing recipient, that he sought out these drugs, but to let this defendant escape or not be held accountable because of the fact that the victim in this case willingly asked for the drugs, willingly accepted the drugs, I think would be an injustice, okay? Let me just wrap this thing up by saying, again, like Lady Justice symbolizes justice overall, you, the 12 of you, are all symbols of justice now. At least for a short period while you're on this jury, you are representatives of Jefferson County and the justice that we consider to be appropriate here in Jefferson County. Like it or love it or not, your verdict will be a symbol. It will represent what we here in Jefferson County believe or think about people who sell and deliver poison to people, because that's what fentanyl is, poison. Your verdict would be like putting a billboard up on I-10 to say that, you know what, one pill maybe may kill, but it's okay to sell the killer pill. So I submit to you that through your verdict, you can either say that we're okay with selling that poison, or you can hold the defendant accountable. You can hold Harry Francis Lowenthal accountable for the crime that he committed. You can find him guilty. Find him guilty not because I say so, or because Deputy Powell says so, or Officer McGraw, or Officer Fraser says so, because find him guilty because that's what justice demands in this case. Find this defendant, Harry Francis Lowenthal, guilty of delivering fentanyl, guilty of delivering that fentanyl recklessly to John, Mary, and Janice. Find him guilty of manslaughter based on the evidence in this case and the common sense. Thank you.
Thank you, Mr. Coleman. All right, ladies and gentlemen, you've received all the evidence. You've heard the court's charge and closing argument. I'm going to give the charge to the bailiff, and she'll get you settled in the jury deliberation room where you will begin your deliberations. Ma'am, if you'll just wait right there, we'll give you your instructions in just a minute. You are all excused to go to the jury deliberation room, and we'll be in recess until you reach a verdict. Let the record reflect state's attorneys present, defendant and defense counsel are present, and we've received a message that the jury's reached a verdict. You can bring the jury in. Did we get discovery certification? We need to do that. Don't let me forget. We need the discovery certification signed with that attachment. You can do it. You can do it later. Just let's not forget. All right, let the record reflect the jury is seated, state's attorneys present, defendant, defense counsel are present. At this time, I would ask the foreperson, has the jury reached a verdict?
Yes.
And is it the unanimous decision of all of the members of the jury?
Yes.
You can hand it to the bailiff, please. Mr. Lowenthal, if you'll please stand. We, the jury, find the defendant, Harry Francis Lowenthal, guilty of manslaughter as charged in the indictment. You can have a seat. Does either party wish to have the jury polled?
State is not lying. We waive that, Judge.
All right, thank you. So at this time, Mr. Lowenthal, based on the verdict of the jury, I accept that verdict and find you guilty of the offense of manslaughter. What that means now, ladies and gentlemen, is that the first phase of the trial is over and we'll proceed to the second phase. It's 4:45. We're not going to start right now. We'll give you guys a break. We'll get started tomorrow morning at 9 o'clock with any witness testimony. There's another charge that'll be read, and then you'll be given the case for deliberation after that. Mr. Coleman and Mr. Reynolds, do either of you have any objection to me releasing the alternate at this time?
No, no, Judge.
So since we've gotten to this point, we want to thank you, though, because it is somewhat surprising to people how often we actually use our alternates. And so we don't want you to think you wasted your time, because we need them. There's a trial next door where they used 2 new alternates in it just last week. So it happens, and we appreciate you, but you don't have to come back. If you need anything for an employer or anything like that, when you leave today, the bailiff can let you know where to get that. So for you guys, all the instructions that you were previously given, you're still under all those instructions. Make sure you don't read or watch anything about the case. Don't talk to anyone else about it. And then we'll get started again, like I said, tomorrow morning at 9 o'clock. I hope you have a good evening. If everyone else would please remain seated, you're excused till tomorrow at 9 o'clock. Let the record reflect the jury is outside the presence of the courtroom. Is there anything that we need to take up before we're done for the day?
No, not from the state judge.
Not from us, Judge.
What I'd like to do in a minute, and we can do it off the record, is I want to go through the notice of intent to use prior convictions and get, if I can, so that I can start working on it either this evening or early tomorrow. I'm gonna have to put all that in a charge. The one thing that this does not say is what level offenses all of those are. And so I need to know the level offense at the time of those convictions for when I put it in the, I think I do.
You list the charge? You
Yeah.
list them in the charge?
Yeah, if it's for enhancement purposes, it's gonna say you have to find them true or not true, correct?
That's true, yes.
I mean, even though it's not in the indictment, if you gave notice,
Okay,
the notice is for enhancement purposes.
okay.
And
That's
so,
what I was thinking. You're right, Judge.
yeah, it would be just like it were if it were in an indictment, since you gave notice of that. And so I need to know which ones are, or what level. Looks like there's, I guess there's the 5 that are listed. If we can get those, y'all can just send it, email it to me or text it to me in a group message on what level those offenses are.
That's what I was gonna say, write it on the motion. If you print it off, obviously, you print the motion off and you just write it.
Okay, also at this time, based on the conviction, I am going to revoke any bond amount that's set. There will be no bond in this case as well. Anything else?
No, Judge. Nothing else.
Okay, and if there's any necessity for thumbprints, can we get that taken care of? Would you like, it's already done? Okay, perfect. All right, then, we'll be in recess until tomorrow morning at 9 o'clock, and I'll work on the charge and go ahead and have it hopefully emailed to you all.